Fanta Diallo, I know fit forget you. Hey Bezina, who's
Hello, good evening and welcome to Hot Edition on 3FM 92.7. It is coming to you live from our studio here at Desawe Kanda in Accra and also on our website 3news.com. Coming up this evening, ECOWAS Community Court throws out former Chief Justice Gertrude Torkornoo's case, describing her claims as without merit and lacking evidence. This evening, we'll ask, is this the end of the legal battle for the dismissed Chief Justice?
Regarding applicants' claim that a consequential removal from office as Chief Justice of the Supreme Court is unlawful, and violates her right to work, particularly that the petition was not for the removal as Justice of the Supreme Court.
We'll delve into that subject in a moment. Also in this evening's bulletin, Narcotics Control Commission dismantles a $200 million charcoal meth syndicate. We'll tell you the details as we have it at this moment.
Through the efforts of narcotics in collaboration with the Bureau of National Investigation and other security agencies, I'm happy to announce that we have picked the lead shipper.
And later in the bulletin, chaos and uncertainty hit a mass of trained but unemployed teachers as they scramble for 7,000 vacancies floated out to them. But the Ministry of Education says all is well. And we'll bring you a wrap of what happened last night. People are still basking in the euphoria of the Black Stars' exploits yesterday when they held the Three Lions of England to a goalless draw. Details of all of that coming your way for the next 1 hour. We have business and entertainment, business and sports, I should say, at the tail end of the show. Before that, let's bring you the news summaries with Nura Mohammed. Hello, Nura.
Hello, Martin. I must say I was particularly glad that we ended with the with the goalless draw. Yes. But first in the summaries, the Chancellor of the Kwame Nkrumah University of Science and Technology, KNUST, Otumfuo Osei-Tutu II, has cautioned chiefs, individuals and other interested parties against laying claim to lands belonging to the university. Speaking at the event marking KNUST's 75th anniversary, Dasante Hines stressed that the university's lands are vested in the schools and legally reserved for the institution's use, insisting that no individual has ownership rights over them. He warned that anyone who supports attempts to challenge KNUST's ownership of its lands in court does so at their own risk. Meanwhile, the Environmental Service Providers Association, ESPA, has attributed the growing piles of uncollected refuse in parts of Greater Accra to a severe shortage of landfill sites, describing the situation as a major challenge for waste management service providers. Now, this follows traders and residents around the Kaneshie market raising concerns over an overflowing refuse container at the market complex, warning that the situation poses serious health risks and is affecting business activities. Speaking in an interview, Executive Secretary of ESPA, Ama Ofori Entry, said rapid urbanization and population growth have significantly increased the volume of waste generated daily, while the infrastructure needed to manage and dispose of the waste has not kept pace. Now, Niger has officially submitted its request to withdraw from the International Criminal Court, ICC, 9 months after announcing its intent to leave. In September 2025, Niger, along with allies Mali and Burkina Faso, which are all under military rule, issued a joint statement saying they would not recognize the ICC's authority, calling it an instrument of neo-colonialist repression. The court said it had received an instrument of withdrawal on 18th June, according to a statement seen by AFP News Agency. Withdrawal takes effect 1 year after notification. That's it for the news summaries. Over to you, Martin.
Thank you very much, Nura. And now let's settle for the details of our stories. We're starting from issues regarding former Chief Justice Gertrude Araba. Esaaba Torkornoo, who was dismissed by the current administration. She did not take that issue lightly, went to court here in Ghana, escalated it to the ECOWAS Court, and earlier today there was a ruling, and the ruling we have is that the ECOWAS Community Court has dismissed the case of former Chief Justice Gertrude Araba Esaaba Torkornoo, challenging her removal from office. The ECOWAS Court, in its ruling, dismissed all her reliefs, citing that there was no evidence of bias or motivation of ill will by the committee that heard her petition or the decision of the president to remove her from office. And in the response to the application by the former Chief Justice, the decision was made today. We have in studio a producer for Hot Edition, Sixtus Dong Ulo Esquire, to walk us through what exactly were the reliefs being sought by the former Chief Justice and what were the responses that she received from the ECOWAS Court. Sixtus, thank you for joining us in studio. So first of all,
welcome.
Remind our listeners who may not be aware of why the Chief Justice decided to take her dismissal from office to the ECOWAS Court, and then we can talk about the specific reliefs that she was seeking. So why did she go to the court first for?
Yes, so she said that her rights were violated. You know, the ECOWAS Court admits people or all citizens of ECOWAS who would have felt that their rights in one way or the other, their human rights in one way or the other may have been violated by a particular country. It could be of any nature. And so you're dealing with any particular country. If you felt that your right had been violated, then you could run to the ECOWAS Community Court with the particular concerns. And in the processes leading up to the removal of the lady Torkornoo from office as Chief Justice, she alleged that her rights had been violated. And these ranged from rights to fair hearing, said those violations also caused her some public ridicule, and also said that she had been subjected to some public ridicule by a manner in which the processes leading to her removal had been conducted. And so she thought that she was not going to get a fair hearing within the jurisdiction, so she invoked the jurisdiction of the community court to look specifically at the violation of her rights in those processes. So that is why she ended up in the ECOWAS court.
And on the back of that, or before going to the ECOWAS court, there were other issues she was dealing with which were in court here in Ghana.
Here in Ghana. And indeed, some of them are still in court here in Ghana. And I'm sure that we'll come to that, those particular and specific cases that are still in court. You recall that she started with in fact, she went straight to the Supreme Court to challenge some of the processes. First, it was the constitution of the Poaman Committee. where she challenged some of the processes of the committee. She was asking about the documents that she needed availed her so that she could prepare her responses, her defense. But she said that sensitive documents critical to her defense had been withheld from her. So all of that culminated in her travel to the ECOWAS Community Court.
Right. So now she goes to the ECOWAS Court. What were the specifics she was praying the court or she was seeking from the court, and what were the responses she got?
Okay. So let's start from the top. She spoke about the suspension and removal from office, which she said was arbitrary. She said her suspension, that was the first claim she made. She said that her suspension and removal from office were arbitrary and were in violation of her right to a fair hearing and due process. And for that, she cited Article 7 of the African Charter, which challenged her suspension and removal from office as Chief Justice. So I'll just run through all of them, and then we will come to what the court actually said. So the first one was that her suspension and removal from office was arbitrary, and that offended Article 7 of the African Charter. The second one was that the inquiry committee was illegally constituted, and that committee, the Justice Poaman Committee is what she's referring to here, that it was illegally constituted. You would recall that back home in Ghana, that generated a whole debate as to the composition of the committee, which composition is actually constitutionally defined. It's not left to the whims of any office holder. The third claim she made was that she was denied access to a judicially reasoned opinion of the prima facie determination and the inquiry report, which also is in violation of her right to information. That report that she's referring to here is the Justice Poaman Committee report. Recall that after everything was done, they put a report together, submitted that report to the president, also in line with the dictates of the Constitution. Right. So she said that particular report, no, I'm sorry, that's not the report. The report here was that report that determined that there was a reason, there was a reason to invoke the Justice Poaman Committee. I don't know if you get the point. Okay, so that she didn't have access to that particular report, which is what she's calling a judicially reasoned opinion, and that report would have, offered her the opportunity to understand what exactly they said triggered all of the action that happened later on. So that denial, according to her, was in violation of her right to information. Again, she is invoking Article 9 of the African Charter. Then the removal also violated her right to work, which is Article 15. And this is actually in every national constitution. You have the right to work, given the permissible age of work. Every citizen has the right to work. You should not be discriminated against per your gender, your race, and all of that.
So she said that because that particular investigation was being conducted, the removal
itself, yes, was a violation of her right to work. Okay. Then she also said the conduct of the respondent breached the principles of least pendants. The respondent here would be the states. Remember that in all of this, it was the republic that had been sued. Yeah. It wasn't President Mahama, it wasn't the Attorney General. The Attorney General merely represented us. The country. But in all of this, it is we the people. Versus the former Chief Justice. The former Chief Justice. Then she asked for compensation for 10 million for moral and reputational damages. Moral and reputational damages. Now, this is what the court said. On the issue of rights to fair hearing, the court said that the government of Ghana fulfilled its obligations of fair hearing. The government of Ghana did not violate the Chief Justice's right to be heard under the said Article 7 of the African Charter. As far as the court is concerned and per the evidence before it, the government did all that it was supposed to have fulfilled, followed through with all the processes, availed the former Chief Justice the opportunity to be heard, set up a committee to listen to him, to her, afforded her the opportunity to appear with her legal representation, and all of that. And that the prima facie determination did not also violate any fair hearing principle, that it is merely a filtering mechanism. If you look at how it is framed in our constitution, it says that before the proceedings can even take place to remove a chief justice, somebody must determine that the allegation that you are bringing against the occupant of the office actually merits the resources, the time, and the attention of the Republic. That it is not the case that Martin would just get up and go and say that the Chief Justice did not watch the Black Stars game, and it is an affront to her duties as Chief Justice. And we set up a committee, then we start looking into it.
Okay.
Somebody must first determine whether even that allegation that Martin has made merits our attention at all. Is this something that we should be investigating? So that merely filters the allegation so that we don't waste our time. And
so again, those are the key reliefs that she was seeking, and now we also have the responses from the court.
Yes.
And it is on these responses that the court said that they do not find reason in her application and that her rights have not been violated in any way.
Okay. In fact, the court said that the claims were without merit, and some of them did not come with any evidence. The rule of the game, as we keep saying, is evidence. Okay. Once you go to court, it means that you have something to back.
When she went to the ECOWAS court, part of the response, which is the final judgment that has been given on her application, is that the ECOWAS Community Court is saying that her application also, on some of the reliefs she was seeking, lacked evidence. So they cannot, grant her wish, because yes, you have a case, but based on what you've presented to us, there is nothing to buttress the point you're making.
You may have a case, but in making that case, you did not bring any evidence to buttress that case that you may have made. Okay. So, depending on which side you are standing, then you can take it from there.
All right. Thank you, Sextus, for updating us on what happened at the ECOWAS court earlier today, where now we do know for certain that the former Chief Justice Gertrude Esaaba Torkornoo's case that she sent to the ECOWAS Community Court has been dismissed. So now let's listen to the court ruling that was read out moment after the panel that had her case and adjudicated over it returned their verdict, and it clearly was to let her know that as it stands, her case at the ECOWAS court has been brought to an end, and that they thought that it did not carry enough weight to allow her any sort of relief or reprieve that she was seeking from the court. Let's listen to the ruling when it was read out.
The court considers that the respondent fulfilled its obligation by affording the applicant an opportunity to submit written responses to the petition, not only before the presidential determination of whether a prima facie case existed, but before her right to be heard crystallized at the hearing of the committee. Accordingly, the court finds that the respondent did not violate the applicant's right to be heard under Article 7 of the African Charter. Regarding the issue whether the failure of the president to provide a reasoned decision in the support of the prima facie determination violates the applicant's right to fair hearing, the court reiterates its earlier observations that prima facie determination is a filtering mechanism rather than a judicial or partial determination of rights of an individual, to which guarantees of Article 7 of the African Charter, including the right to reasoned decision, apply. The allegation in that regard is therefore dismissed. The court notes that matters relating to the procedure of national courts or tribunal, quasi-judicial bodies, as well as the competence or compatibility of witnesses, compellability of witnesses to testify, are issues that are primarily regulated by national laws of member states. Even that issues related to whether the petitioner ought to have testified and which rules of procedure should have been applied by the committee are matters of Ghanaian law, over which the court has neither original nor appellate jurisdiction. The court considers that they fall outside its mandate and they are accordingly dismissed. In view of the foregoing, the court concludes that the applicant was not denied the right to fair hearing under Article 7 of the African Charter in the President's determination of prima facie case, and also that the committee, and also before the committee appointed to determine the petition against her. The issue for determination, the first issue for determination is thereby dismissed. The second issue for determination is whether, contrary to Article 7 of the African Charter, the committee set up to determine the petition against the committee was not competent and impartial tribunal. On this issue, the applicant submits that the composition of the committee inquiry was defective. Regarding applicant's claim that a consequential removal from office as Chief Justice of the Supreme Court is unlawful and violates her right to work, particularly that the petition was not for the removal as Justice of the Supreme Court, the court is persuaded by the respondent's submission, which were well supported by relevant provisions of Ghanaian law, that the applicant's membership of further superior court flows ex officio from her office as Chief. Such other superior courts include Supreme Court, the Court of Appeal, the High Court, for which no separate removal proceedings are required. It will be absurd to commence separate procedure to remove the applicant from all these other courts, of which she was an ex officio member, after her removal from office as Chief Justice. For this reason, the court finds that the applicant's contention in this issue is without merit and is accordingly dismissed.
So that was the verdict read out by the head of the ECOWAS Court, who earlier today addressed the petition that was filed by former Chief Justice Madam Gertrude Esaaba Torkornoo. Like we indicated earlier, some of the cases are in court. Some of the issues she had with her removal were sent to court here in Ghana. She started from the Supreme Court. There was one that also went to the Appeals Court. But because she, based on information we've gathered throughout the process, because she had concerns about fair trial, she thought that taking it out of the jurisdiction was going to give her some extra leverage where she would be heard properly, her case would be made strongly before a decision was to be taken. And, well, it did not go as she planned, but at least she put in the effort to get the ECOWAS Court to look into the case. And earlier today we heard that case has been dismissed. And so for those who may not have followed exactly what has gone on in the time past, Wisdom Safo with our research desk has joined us in studio to help us, go down memory lane. How did we begin this whole saga concerning the former Chief Justice? Wisdom.
So Martin, we go back to 25th of March 2025, where President Mahama received 3 petitions. So on 25th December 2025, President John Mahama received 3 petitions, and one was from Daniel Ofori, a businessman and of Shining Star of Ghana, and Ayamga Yakubu Agoglo, and they identified as they alleged that there were issues involving he proposing Supreme Court appointment, her involvement in certain cases, alleged remarks on court users, misuse of public funds and all. So on 25th March, that's when this whole process started. And take note, on December 2024, there had been an earlier petition that was submitted to former President Akufo-Addo, but that petition failed. On 27th to 28th March, Gertrude Torkornoo asked for the petition to be presented to him and to present it to her, and she asked for 10 days to also submit or prepare her defense. She submitted her defense on April 4th to April 7th, and actually the president gave her more time than she requested for. So the president on 22nd April 2025 suspended her and set up the committee to determine whether there's a prima facie case against her. By 25th May, the NPP started a demonstration. They led a demonstration against the suspension and the removal process. By 21st May 2025, Gertrude Torkornoo files her own Supreme Court action. So she filed an application at the Supreme Court, and this application is to stop the committee from continuing its work. It also challenged the participation of some committee members, including Justice Puamai. By July 4th, that's when she filed the case at ECOWAS. So she filed a case at the ECOWAS court. She was asking the regional court to suspend the ongoing removal process. This comes after the Supreme Court dismissed her injunction, which sought to, halt the committee process. And by July 14, the ECOWAS court heard the arguments from both sides, both the defendant and the applicant, and now here we are. Currently, the ruling that we have, that most of all the cases that he presented or the relief that she sought has been dismissed. Okay.
Wisdom, thank you for that, trip down memory lane, especially for those who are hearing for the first time that the Chief Justice's case at the ECOWAS court has been dismissed. At least that is like a brief background to what happened. Yes,
Martin, I want to say this on record that if you look at the Fourth Republic, Ghana has had about 8 to 9 justices of the Supreme Court, if you want to include Bafo Boni, the recent Chief Justice. And about 7 of them have had petitions against them, but none has been successful. Okay. And the Chief Justice with the most petition is Gertrude Esaaba Torkornoo, with 4 different petitions against her, and successfully one has a prima facie case agreement. She's the first Chief Justice under the Fourth Republic to be removed from office.
Okay, thank you very much. That is a very important point to note, that yes, it's not like no other Chief Justice has had any form of challenge to their position, but for the first time in a long time, at least another Fourth Republic, a Chief Justice has been removed because a petition was filed against her. And then when the investigation was conducted to establish a prima facie, it ended up that, yes, truly, she was found wanting or had fallen short of expectations of the law. And on the back of that, she has been removed from office. But she's been challenging all of this right from the onset of a letter from the Office of the President asking her to, step aside for investigations into the petition that was filed, to get her investigated. Well, back home here in Ghana, what exactly are the active cases that the former Chief Justice is still pursuing? You'll recall that in my interviews with both Sixtus and Wisdom Safo, we talked about the fact that the former Chief Justice was fighting her removal both in Ghana and in the sub-regional court of ECOWAS. But the ECOWAS court seems to have some finality to it. We heard the verdict. But in Ghana, what are some of the cases that she's still pursuing? Lord Edwasare is our court correspondent. He joins us in studio. Lord, thank you for your time. So remind us, what is the Chief Justice still pursuing in the Ghanaian courts?
Martin, like you rightly indicated, quite apart from the suits which was filed by the former Chief Justice Gertrude Araba Esaaba Torkornoo, there are other legs still related to her matter in various courts. So, for example, there are 4 active cases at the Apex Court, the Supreme Court, that is challenging the processes that led to her removal. You'll recall that one was filed by Vincent Assefuah, the Otafo Member of Parliament, and then there was also one filed by a private individual, Theodore Atakote, and then there's another filed by Center for Citizenship, and then the 4th being the former Chief Justice herself, Gertrude Torkornoo, where her counsel or her lawyer is the former Attorney General Godfrey Abadame. Martin, you recall that the last time the case was in court, the former Attorney General served notice to the court that he was withdrawing his services as lawyer for the former Chief Justice, which was shut down, but then his arguments were still adopted. Now, those cases have been consolidated from 4 and been merged into 2. So that matter, the final judgment for those cases is on July 2nd. That's the date that the Supreme Court has indicated that they're going to give the final ruling on the matter. And then there's another leg at the Court of Appeal, and again another at the Human Rights Court, still challenging the processes. You know that she's been arguing that, for example, the processes were inhumane, they were unconstitutional. So she's been arguing on the front of her human rights being violated, some of which she escalated at the Community Court of Justice of ECOWAS, where she indicated that the processes undermined her, made her a public ridicule, for which it was eventually shut down. But these are the cases that locally here or in Ghana here are still active regarding Gertrude Torkornoo, the former Chief Justice.
Okay, Lord, thank you for that. And so again, just as so we are sure we are on the same page, there were a number of cases, but as it stands, it's just 2 active cases that she's pursuing in Ghana. There were 3, essentially, right? There were 4 at the Supreme Court, which have been consolidated into 2. Okay. And then there was one at the Court of Appeal and another at the Human Rights Court, which is the High Court. Okay. Yeah. So in all, 3. 2 at the High Court, 2 at the Supreme Court. Superior Courts. One at the Court of Appeal, and then 2 at the Supreme Court. Okay. All right. Lord, thank you for that update as well. It means that although the ECOWAS Court seemed to have come to some conclusion regarding the former Chief Justice, when it comes to the local courts or the courts here in Ghana, the former Chief Justice still has some very strong cases, both at the Supreme Court, the Court of Appeal, and the High Court. That is, we'll update you on any other developments when they do come up regarding when the next date of hearing will commence. But following the decision of the ECOWAS Community Court, some members of Parliament have been reacting to this decision of a total dismissal of the cases, the case of the former Chief Justice. Let's listen to the members of Parliament who had varied opinions on the matter.
I'm quite surprised in the court throwing away the case, especially in terms of the human rights violations. You know, for the $10 million suit, that one I can agree to it, but I am quite surprised because if you look at her case and how he built it, and the basis that on the basis that she was removed, people are doing far more than what she did now, but they are still at post. And these bases, you can infer that it was planned and it was predetermined, because they decided her case even when they were in opposition, and basis the fact that this has never happened before in the history of our country. It was putting the justice system into jeopardy. And so I was expecting a better response from ECOWAS, at least to see her case, try it and let us know that justice is being pursued. The committee was basically a rubber stamp committee. Look at the Council of State, the composition of the Council of State. How many people the Council of State has turned into a political organization at the moment. Looking at the composition, it was only Justice Akufu, yes, who abstained. And they should have taken cue from her abstention to draw some inferences and conclusions why she abstained, to mean that Torkornoo was not being treated fairly. But because, it had turned somewhat political, they had to toe the line. So if, of course, you can't question the procedure. No one is questioning the procedure. Yes, the procedure is constitutional and they follow the procedure to the letter. But then the intent and the motive behind it is what we are questioning. And this is, you can have the best of procedures, go through the process as it is, but then you will still not receive justice. My case is that, you see, pending, based on what's the outcome of the ECOWAS, I don't see it as it's going to be a different verdict from what ECOWAS has judged. Because if even the external courts did not grant the reliefs that she sought, I don't see how, internal courts here will do any justice to what she's seeking. So, I mean, she should just exhaust the process. I mean, it's a constitutional right. Let her exhaust the process and let's see how it goes.
Thank you.
I've always maintained from the beginning of the case that Justice Torkornoo had no case. She had no case because the president acted in consonance with the provisions of the Constitution. And I, once upon a time, even indicated that if the president had not carried out the recommendation by the committee, it would have been a ground for impeachment of the president, because the Constitution has set out procedure for the removal of the Chief Justice, and there wasn't any procedural impropriety on the part of the president. So I wondered where the human rights violation came in. However, it is, a victory for democracy. A victory for democracy because the rule of law is what we must all maintain. It is after you have exhausted local remedies that you go to the international front. You remember that the Attorney General filed a preliminary objection which was put aside, and the court said that we are going to take over the matter. So it is done. It is finished. I am a human rights activist, and I stand by that, irrespective of whoever you are. Insofar as your right is being trampled upon, I have to stand with you. But there wasn't any human rights violation here. So why would you manufacture human rights violation that your right has been trampled upon? You know that the Constitution sets out procedures for doing things. So she was saying that there was natural justice. So she's saying that the government, the leadership or the president did not go, or the committee did not go according to the ordering partum rule. You understand? But they are saying that, no, we did. We heard you. And the courts, the ECOWAS court, in fact, it started with our courts and to the ECOWAS court. And the ECOWAS said, courts have come, even though we haven't seen the ruling, the details of the ruling. But they have dismissed all. In fact, it was a unanimous decision. And unanimous means that all of them, all who sat on the case, said that, no, you don't have a case.
And you heard some members of parliament reacting to Madam Gertrude Esaaba Torkornoo's dismissal from the ECOWAS court, her petition that she was seeking against her removal from office as Chief Justice. And so let's get further reactions to this. Former Member of Parliament for the Tamale Central constituency, the Honorable Inu Safishane, has joined us for a quick chat on this. Honorable, good evening. Thank you for your time.
Good evening. Thank you for having me.
What would your immediate reaction be to the dismissal of the case of the former Chief Justice? Were you surprised, or it was expected that there really wasn't enough substance in her case, so you are not surprised about the dismissal?
The dismissal was long in coming. I mean, I had said that it would be surprising if the ECOWAS court comes to a different conclusion, because the procedure stipulated under the Constitution had been religiously followed by the President, and there was no breach of any of the provisions of the Constitution in connection with the removal of a Justice of the Superior Court of Judicature in this matter. And so to say that you were not, you had issues with the removal process and escalating the matter to the ECOWAS Court of Appeal, you were inviting the court to see whether or not there were breaches of the procedure provided under the Constitution, which breaches inured to your benefit as it affected your human rights. But the court said no. They were of the view that all the procedure provided by the Constitution and all the provisions of the Constitution were adhered to.
And does this bring finality to the case, or she still could pursue it in other courts?
Well, so this is the first time the Chief Justice has pursued a matter to even the international court. When it happened in the first case, Akokosa, took it lying down. This Chief Justice has decided to fight it. Case to next. All we need to do is to see where she goes and what will be the release that she's taking.
Right, and so in conclusion, to the layman, although she still has some cases active in Ghanaian courts, the one she took to the ECOWAS court is totally dismissed, and because of course they said there was no evidence or she couldn't prove ill will. But what happens to the cases that are still active locally?
So the Ghana courts will have to deal with them, and particularly the Supreme Court will have to deal with those cases. And I'm sure when the cases are listed, we'll follow to see what happens in the courts.
Honorable Esaaba Hussaini, thank you so much for your time this evening.
You're welcome.
He's a former member of parliament for the Tamale Central constituency, the Honorable Esaaba Hussaini, helping us with some perspectives on the Gertrude Esaaba Torkornoo case. Clearly, it's one of the most topical subjects in the country, and I believe that we've brought you different angles and perspectives to also help you understand what has gone on, and that the former Chief Justice, according to the ECOWAS court, was not dismissed on any evil or negative grounds. The court believes that due process was followed in the lead up to her dismissal from office as Chief Justice. And then again, that is the ECOWAS court. Although there are some cases still in Ghana, we are only waiting to see how all of that will play out when the due date for their hearing does come around. But your thoughts on this subject, very welcome. We are happy that you're following our streams on Facebook and on Twitter. Also on YouTube, you can get Hot Edition. Just look for 3FM 92.7 and you can be a part of the conversation. Stay with us. When we return from this quick breather, we'll take you to some other very disturbing stories where the Narcotics Control Commission has dismantled a $200 million Chaco meth syndicate. Details of that and more in a jiffy.
Everyone
92.7 is the dial. 3FM is the station. My name is Martin Asiodudati. You're listening to Hot Edition. We're going on to some other stories we have for you this evening. And the lead shipper, a female Ghanaian national in the $208 million Australian methamphetamine scandal, has been arrested. According to the Director General of the Narcotics Control Commission, Brigadier General Maxwell Obuba Mante, the operation took 3 nights in collaboration with the Bureau of National Investigation and other security agencies. This came to light when the Narcotics Control Commission today destroyed some 46.89 kilograms of cocaine, 9.6 tons of cannabis, and 130 boxes of hemp-related products following a court destruction certificate. The illegal substances were intercepted between the years of 2011 and 2026. Let's listen to the brigadier who has been speaking to the media. That is the Director General who spoke to the media following the destruction of these narcotic and other drugs that have been impounded following operations across the country.
Today we are gathered not merely to destroy narcotic drugs and controlled substances, but to demonstrate Ghana's unwavering commitment to protecting public health, public safety, and national security. The substances being destroyed this morning were lawfully seized through the dedicated efforts of NACOC and our partner security agencies, and have gone through the requisite legal processes to get the permission to destroy them. This exercise represents the final stage of our enforcement efforts and ensures that these dangerous substances never find their way back into our communities. For this morning, we had 9.6 tons of cannabis, 46.89 kilograms of cocaine, 2,734 bottles of cannabis-laced drinks, 130 boxes of hemp-related products, and others that the court permitted us to destroy. Collectively, these substances represent thousands of doses that could have fueled addiction, destroyed families, and endangered young people, as well as strengthened criminal networks. This destruction sends a very strong message, and I mean a very strong message, and an unmistakable one, that Ghana remains resolute in denying drug traffickers and criminal networks their profits from illicit drug activities. This exercise also demonstrates our commitment as an agency, or the lead agency, to transparency, accountability, and adherence to international drug control obligations. That is why my Director for Public Affairs mentioned to you that before we sought court clearance, we had officials from Ghana Standards Authority come to the Commission. They inspected, weighed, and tested the products that were earmarked for destruction. After that, we listed them and sent them to the courts for approval. And when that was granted, Ghana Standards Authority came back here again to test them to be sure that the drugs were what we were authorized to destroy. They weighed them, packaged them, and ensured that what they did corresponds with what we have here. The fight against drugs cannot be won through seizures alone. Prevention, treatment, and rehabilitation, as well as public education, remain critical to our pillars and to our national efforts. That is why I mentioned the last time that apart from enforcement that involves arrest and prosecution of persons who engage in illicit drug activities, we also do education. We come to you, the media, we engage with you, you ask questions, we clarify, you go to faith-based institutions, we talk to the kids, we talk to the patrons of that institution, we go to secondary schools, we educate them. And for your information, just yesterday, for the first time in the life of the commission, we organized a seminar for the guidance and counseling teachers across the country, 16 regions, 50 from each region. That is a milestone, and I'm happy it went very well. It's part of our efforts to curb illicit drug activities, especially among students. Before I conclude, let me inform you that I'm aware that you all know of the Australian methamphetamine saga. Through the efforts of narcotics, in collaboration with the Bureau of National Investigation and other security agencies, I'm happy to announce that we have picked the lead shipper. We did that over 3 nights. My officers slept out of their homes for 3 months and successfully picked the person who...
So you heard the voice there that gave a breakdown of the total number of substances that have been destroyed, but more importantly, the fact that the recent methamphetamine reports that came out regarding how that sacks of charcoal that left Ghana was impounded later in Australia, was found that it was not just charcoal, but it had methamphetamine in there as well, a street drug that is very expensive, and the drug lords actually wanted that to get on the streets. But the Ghanaian authorities have also, following a tip-off, been able to arrest a female Ghanaian who were told that she was the brain behind the export of those bags of charcoal. The street value of the methamphetamine, we are told, was around $208 million, and that was some good money that has been stopped from getting into the veins of young people and eventually might end up destroying them. Well, before we go to business, let's touch base briefly with the sporting team and find out how they felt following Ghana's draw against the Three Lions of England. And clearly, a lot of people are still basking in the fact that we were able to hold our own and at least secure a point going forward. Murtala Mohammed has joined us in studio. Murtala, thank you for your time. Yesterday, when we were speaking, you gave us an idea that Ghanaians were cautiously optimistic, but a lot more optimistic than being cautious. Fortunately, the game ended in a draw. Would you say that we should have pushed for a win, or the draw is much better than, maybe attempting to get a win and then end up losing?
Well, there was no better way we could have played than what we did against England, because we couldn't have gone there to flex our muscles and show them that, we are co-equals in terms of quality. The gulf in quality between us and them is huge. There was no other way we could have played against them. And if you're playing against a team that has so much quality like England, you have to do the low block. Once you do the low block, your moments would come, but it's about how you're going to capitalize on your moments. We had our moments as well. That Prince Edu Kwabena opportunity should have been a goal. I'm sure you will say if it was 6 years ago, Asamoah with that opportunity, it's 1-0 for Ghana, because you have to sit deep. But one thing I told you that we didn't have to lose was our organization, and we needed to keep the concentration from minute 1 to the final whistle, because England will keep coming. Now, the conversation is about how Thomas Tuchel isn't good enough, how the English team lacked creativity and all that, because we kept them at bay. There was no other way Carlos Queiroz could have set his team up to play against England than what we saw. Good point for Ghana. Now they are into the round of 32. All they need to do is get a few points or get a point against Croatia and see whether they would finish a bit up higher. But as it stands, even if they are taking 8 teams as the third best placed teams, Ghana would be there with the 4 points.
Now, again, the other major issue people are talking about is going forward. Our next game is against Croatia. What should we throw caution to the win and go for a win at all costs, or still be cautious in our setup?
So I'm looking at the holistic idea that is running through the mind of Carlos Queiroz. Third place means that you would be playing some of the high-ranked teams that are finished first, teams that are likely to finish on top of their group: Spain, France, Argentina, and Portugal. You would want to avoid these teams at the moment. Croatia is not as great as we thought some years ago, like 2018 when they got to the final. They have a more aging team now. open up and play against them. Because there's one thing that is clear. Croatia would come at Ghana because they have 3 points and they need to win at all costs. And they would also want to finish higher than being third. Because if you finish third, the likelihood of going out in the next round is high. Because you're coming up against the best in the world. Yeah. Even the host nations, you would have to avoid them. Because I wouldn't want Ghana to play either Mexico or USA at the moment. Yeah. Maybe when going for... Because with the host nation, the tournament always favors them. Yes. Even refereeing decisions sometimes goes against them. Yes. The 12th man, the stadium will be cladded with just home fans. Yeah. So Ghana should push forward. It's not as if we couldn't even have scored a goal against England. We had our moments because they were playing the high line and pushing forward. Croatia will come at us. They have an aging team, but I feel we need to change some personnel. In that game against Croatia, I wouldn't start Inaki Williams. I would want to start Fatai Sahaku, who tries to get a goal from every part of the pitch where he is. And also, the idea of sitting back and defending must change. We must be a bit forthcoming and move forward with our possession.
I think that the coach has actually helped us with, a lot of people who are not ardent football followers were like, Ghana, why are you sitting back? It is a tactical move. And maybe like you're indicating or advising, the coach must look at changing and tweaking. Let's put some of our pacey players on the pitch, run against this aging Croatian team, and hopefully nick not just a point, hopefully the 3 points, and it will be to our favor. Well, when is our next game?
Saturday, Croatia, 9 p.m. They are attempting to win. They don't have, their coach said it when they beat Panama yesterday. But there's one thing we need to think about. The Panamanian team are not as cheap as we thought. Because beating them 1-0, we thought that Croatia would just go and walk over them. But
it wasn't easy.
Hurricane will send his anger to Croatia. That one we don't mind. Because Kweku Bunsan says he has released him.
For all you know, England might go and lose against Panama.
Well, that would be good for us because we would end up topping the group. 2014, England were in a group that contained Costa Rica. Surprisingly, Costa Rica topped the group. England finished second, and it wasn't good for them. Currently, the English media are on the neck of the team. They felt that, they had zero idea of how to play.
Exactly.
It's not easy when you are playing against a team that wants to sit deep and defend, and a team that is very organized and disciplined. Throughout the entire 96 minutes that we played, we had just a card. It tells you how disciplined the team is. And that was the same way Quebec did against Spain. Be disciplined, don't go in for the rough tackles. Once you get the tackles coming in, they'll get more free kicks and they could punish you. But it looks like there is some positivity around the Black Stars. I've always known that when it comes to the Black Stars, it's a national call. But the air blowing around the team right now is different. It looks like everyone, irrespective of where they stand, wants to be behind the team. Let's see what happens on Saturday.
We'll see Black Stars. Thank you very much, Murtala Mohammed, for the update you've given us from the camp of the Black Stars. In a moment, we'll be going to the business world to find out what else is happening in the world of business, and Bismarck Eusa will join us in a moment. But some of your messages coming in. Paparaze Yao says that he sent us a message on the Justice Gertrude Torkornoo issue. He says, if you are dismissed in the ECOWAS Court of Justice as an external court, can Mrs. Torkornoo survive in internal courts of justice? My advice for her is that she should go and rest with her grandchildren. Well, that's your thought. Thank you for sharing it. Time now, though, for the latest in the world of business.
Hello, good evening, and welcome to the business segment on Hot Edition on 3FM 92.7 with me, Bismarck. Also coming up tonight, proposed $210 million Atlantic lithium takeover by Chinese firm raises fresh concerns over Ghanaian ownership and local participation in the Ouya lithium project. Thanks for your company. Now to the details. The proposed acquisition of Atlantic Lithium by Chinese battery materials giant Huayu Cobalt is drawing attention beyond financing and mine development. Concerns have emerged over the future of Ghanaian ownership and local participation provisions embedded in the Ewoya Lithium Project mining lease. Under the mining lease, Atlantic Lithium was required to maintain a listing on the Ghana Stock Exchange to allow Ghanaians to directly own shares in the project, while the Minerals Income Investment Fund, MIF, was also granted an equity participation role. However, Huayu says Atlantic Lithium would be delisted from the Ghana, London, and Australian stock exchanges if the acquisition is completed. This raises questions about whether the local ownership objectives that formed part of the lease agreement can still be achieved. While the state's 13% free carried interest appears protected, analysts say the future of MIF's investment and retail Ghanaian shareholders remains uncertain. Based on the proposed offer price, MIF could exit its stake at a marginal loss, while many Ghanaian investors who bought shares on the Ghana Stock Exchange may also face losses. The transition is subject to regulatory approvals, with authorities expected to assess not only the legal aspects of the deal, but also its consistency with Ghana's local participation goals for the Ewoya project. And that was a 3 Business News Desk report on a proposed $210 million Atlantic Lithium takeover by Chinese firm, raising fresh concerns over Ghanaian ownership and local participation in the Ewoya Lithium project. And that brings us to the end of the business segment on Hot Edition on 3FM 92.7 with me, Bismarck. Also, for more business stories, please check out our website, 3news.com. Thanks for your company.
And that's it for Hot Edition on 3FM 92.7. Thank you very much for doing the listening. If you go to our website, 3news.com, you'll get all the stories we brought to you this evening and several others. And we thank you for your company as always. My name is Martin Esaaba. Bye for now.